Friends, this is an interactive session and all of you are here to listen to the speakers and learn something from them, where I personally feel lectures and other things have no place, excepting hearing Mr. Pandya, Mr. Kavina and Mr. Anand, and thereafter, as he rightly said, that there has to be interactive session depending on time and your mood. All that I would say is that I am very happy that the strength today is little more than what it was last time. It's good that they gave me to speak something, but all credit goes to Mr. Pandya because I have played no role in this function. And I hope he keeps it up on very regular basis. All that I want to convey is, before I conclude, is that please tell your friends that this is extremely useful. This is not only useful, but this is going to be a guiding factors and issues to you in future. It gives me little pains that when we organize a cricket competition, 500 people, 500 juniors participate, but on such an important seminar, not small in number, but small as compared to participants in a cricket match, this reflects a very sorry state of affairs. I am going to address letters to each and every junior to please be little more attentive towards their practice, committed towards their practice, and these are the platforms that you get to learn. When you hear Mr. Kavina, you will not only stand to gain in terms of law, but you will also improve on your English. I am very sure about that. So such things also are sometimes, though besides the point, very helpful. Please, apart from my letter reaching to each member, for your recognition, for you to be known in the bar, this is not a place where you come at 11 and go at 5 o'clock and going to the office or your residence, you count the money that you have earned. This is a platform where you can earn your reputation, you can earn your recognition as a good lawyer. In good old days, there used to be a very regular seminars every second Saturday. And in those days, when the strength of bar was 500 or 450, more than 200 juniors used to attend, who later on became right up to judges of the Supreme Court. Please circulate my message to all your friends that do attend such seminars, and it's a free hand from my side and all my members of the managing committee to Mr. Pandya to please keep on arranging such seminars. If not today, tomorrow we'll find 1,000 junior friends sitting here. It's ultimately for the benefit of them, and I'm sure sooner the better they would realize it. Thank you very much. Thanks a lot.
Thank you very much, Yatin bhai. Moving on to the next session is equally interesting. I would consider it as a continuation of the first one. When Mr. Asim Pandya has revealed the true identity of Article 226 and has strongly resented that the word writ is a wrong nomenclature, but then the next question that would arise is, what about the petitions which are to be filed under Article 226? What are the do's and don'ts? What are the precautions that are required to be taken while pleading a particular thing in the petition? For this, no one else than Mr. Percy Kavina could able to guide us better. I would invite Mr. Percy Kavina, who is a senior advocate and the member of our association, to deliver a keynote on the today's half-day seminar on the subject, and please enlighten us. Mr. Percy Kavina, please give him a big round of applause.
Thank you, friends. Actually, the idea is today to share with you people the sum total of the mistakes which I have learned, committed and seen in the High Court. So my friend Asim's lecture was very illuminating. Even I took some notes, because he tells us of what things should be. He's always been an academic sort of chap since the time we joined practice and had our office together. I am now going to talk about what things are or should not be. So I have prepared the scheme of today's talk on the basis of what are the pitfalls which practitioners of the High Court should avoid. In other words, kai common bhulo na karvi. And much of what I say are the mistakes which I have committed, so I plead guilty to them right away. But if you are able to have an inquiring mind, at least one thing will happen, that you will not make the same mistake again, because mistakes we will make. We do about 105% of our learning on the job. That is to say, what you have studied in the college, you come here, then you come here, and then you forget all that, and then you study again. So much of what we learn is on the job. We unfortunately are learning at somebody else's cost, namely our client, namely the judicial system. So let's try and make as few mistakes as possible. So I am taking as our blueprint or as our rubric, that's a difficult word, look it up in the dictionary, and if anybody makes a comment about it, tell them that it's a word used by the Supreme Court of India. If you don't know the meaning, you go and check it. A High Court petition. Most of you are almost exclusively practicing here. So what is the first line which we have in the High Court petition? First line, first. In the High Court of Gujarat and Ahmedabad. So now that is my first topic. You are a practitioner, you hold yourself out, you put your board, you buy your AIR Supreme Court, you buy your states, you buy your manual, you set up for practice, and a guy comes to you. Your instinct is to file something in the High Court. Wait. Please wait. Because the first duty you have is to see કે ખરેખર હાઈકોર્ટમાં પિટિશન થાય છે. And many times the answer to that is no, no, no. It will be a difficult no for you to say, because probably you are not practicing or familiar with the tribunals where the matter ought to go. But please do say so. For example, a civil suit which has been filed before the Senior Division Court. આપણને એમ કે સિનિયર ડિવિઝન હોય એટલે હાઈકોર્ટમાં અપીલ થાય. Not so. Many suits go before the Senior Division Court because the Junior Division Court is not established. Others go before the Senior Division Court because by virtue of the fact that the government is a party, it has to go before the Senior Division Court. But if valuation is below that cutoff, whatever it is, then the appeal will go to the district court. If you file an appeal here, chances are notice to nikadse. Presiding officer may not know. Samawalane chokkas khabar hase. He will come and expose your ignorance and you will look silly. You will have wasted time, you will have wasted money, and probably you will lose the class. Probably he will go to the district court, but he will not come back to you probably. So please pay attention. If a guy comes to you with an order passed by the collector, whose office might be just down the road, and you have heard somewhere that collector no order bhi hai, question થાય છે, but જો revenue no હોય તો please અહીંયા ના કરો. Go to special secretary. ડેપ્યુટી કલેક્ટરનો ઓર્ડર આવે આપણે કહીએ કે ના ના તમારા કલેક્ટરમાં જવાનું વેટ યુ આર હાઈકોર્ટ લોયર યુ શુડ નો બેટર if that order of the deputy collector is passed under the tenancy act or several other acts like private forest acquisition act the appeal will go to the tribunal Gujarat revenue tribunal so you had better when you are dealing with rank and file people who will cross the threshold of your office you had better know કે ફર્સ્ટ તો અહીંયા થાય છે કે નહીં and as value addition because we strive to be better today than we were yesterday you should know where the matter will go you can't just say અહીંયા ના થાય અને કાયદામાં એક પ્રેસિડેન્ટ છે આવા કે સપોઝિંગ યુ ફાઇલ અ suit in a court which has no territorial jurisdiction and it will return the plaint to you for presentation before the correct court કાયદામાં જોગવાઈ છે કે when the court comes to a tentative decision કે મને હુકુમત નથી court can be asked to opine કે by the party applying કે should I file it in this court would that be proper so when something comes to you please know where that remedy lies and tribunals are there there is now more and more as Mr. Pandya said administrative law has taken a stranglehold of much of the litigation which we come across and there is a wide proliferation of tribunals and it is a maze एक ज व्यक्ति if he is acting wearing one hat his order or her order will be challengeable before forum A and the same officer wearing another hat order will be challengeable before forum B so first question whether High Court has any jurisdiction or not is the first question you have to ask yourself the next line we write is district why district it's not immediately relevant it is actually an administrative tool but when our notices are issued they are served through district courts therefore be clear many in the last 10 years in Gujarat there has been a proliferation of the districts I remember when I started practice Valsad used to come under Navsari I used to do a suit there the senior division court was under Navsari district court then Valsad got a separate district and by the time the suit was heard exhibit 5 વખતે it was before A district when the suit was decided appeal came the district had changed so there is a wide number of districts and this district is very important when you have filed a caveat ખોટા ડિસ્ટ્રિક્ટની caveat કરી સામેવાળો મને હુકમ લઈ જશે so be very careful about the district then comes that huge question about what type of litigation shall we file in the High Court so when I was preparing for this talk I checked the High Court website and special CNA first appeal there are 82 types of petitions proceedings you can file in the High Court 82 and if you don't get it right your matter will not get circulated if it gets circulated the judge will scold you if the judge doesn't spot the difference as I said the other side surely will so please figure out what it is because much of this decision will govern the width of jurisdiction which you are asking the judges to invoke. Now, something has been said about revisional jurisdiction, something has been said about appellate jurisdiction, and something has been said about original jurisdiction. These words matter. There is some reason why these words are used because they affect the amplitude, the width of the jurisdiction. Revisional jurisdiction taken in the criminal context was only errors of law will be seen, errors of fact will not be seen. In the second appellate jurisdiction, only substantial questions of law will be seen. In civil proceedings, in second appeal, only substantial questions will be seen. In an appellate jurisdiction, which is the first appeal, it will be a full-fledged rehearing of the case. So be careful. I remember as a very young lawyer, I had seen somebody who is much senior to me approach the learned single judge by way of what he said is entitled second appeal. It was before Justice Y.B. Bhatt. And Justice Y.B. Bhatt asked him कि हमारा second appeal केवी देता है? तो मैंने कहा क्या साहब जो order हूँ challenge करूँ छू, that is an appellate order. So the judge asked him कि yes, it's an appellate order. So he said then this is the second appeal. See, every second appeal is not a second appeal. Turns out that the order was passed initially by a single judge of the small causes court. It was a rent suit. And that rent suit resulted predictably in a rent appeal. Again under the Rent Act, which is decided by a division bench of the small causes court. And after that, BG appeal provide nathi kari. Pachi there is just a revision with its necessarily limited scope of jurisdiction. But he thought કે સિટી સિવિલના કમ્પાઉન્ડમાં સ્મોલ કોઝિસ કોર્ટ છે, સિટી સિવિલ પણ ત્યાં હતી, સ્મોલ કોઝિસ કોર્ટ પણ ત્યાં હતી. હવે ત્યાંના એપેલેટ ઓર્ડરમાં શું થાય તો કે ભાઈ હાઈકોર્ટમાં સેકન્ડ અપીલ થાય. Please don't make this mistake. It was deeply embarrassing for all of us also that that lawyer was humiliated so badly. So, another example. Company Law Board exercises certain powers. Any appeal from the Company Law Board comes here under 10F. Any appeal under any special law, for example, the special law, Income Tax Act, there are land acquisition laws. There is one rule in the Gujarat High Court rule which says that all special act appeals, એટલે કે appeals provided to the High Court under special jurisdictions shall be treated as first appeals and shall be numbered as such and be heard by a division bench.